All right, if we can start getting things underway, we have two major sponsors coming. First, Paul White, and he is raffling off a gun. I'll defer to him to explain what type of weapon it is.
It's a little L-10 P380. It's a pocket 380. We've got shirts, hats, a couple coupons for concealed firearms class. So make sure you get a raffle ticket. Be honest, just get one of them, but at the end we'll be giving away that gun for free. Somebody's going to be smiling.
Yeah, someone indeed be smiling. The next sponsor is Clay. He will be raffling off a holster for the gun previously mentioned. Clay, if you can stand up.
Yeah, my name is Clay Moultrie. I'm the owner of SHTF Gear Holsters. Basically, you'll be getting coupons. Part of that money will go, if you purchase a holster with that coupon code, you'll get a discount, and $10 from each sale will go to support the organization. And then, as he said, we'll be auctioning off a holster for that gun should you win it.
All right, thank you. Those are our two sponsors. Just to let everyone know, we also appreciate your financial support if you help us out. But all right, grab a pizza, grab a seat, and we'll get things underway. All right, so as some of you may already know, my name is Justin Hinn. I'm the president of this school's chapter of USU Students for Liberty. This is one of the major events that we're holding this semester. If you're more interested in our club, we have information in the back as well as a sign-up sheet, or please talk to me or one of my members. Today I am honored to present to you Mr. Levy. Mr. Robert Levy is chairman of the Cato Institute's board of directors. He joined Cato as a senior fellow in constitutional studies in 1997 after 25 years in business. He also sits on the board of the Institute for Justice, the Federalist Society, and the George Mason University School of Law. He founded CDA Investment Technologies, a major provider of financial information and software, and was its CEO until 1991. Levy clerked for Judge Royce C. Lambert on the U.S. District Court in Washington, D.C., and for Judge Douglas H. Ginsburg on the U.S. Court of Appeals for the D.C. Circuit. From 1997 until 2004, Levy was an adjunct professor of law at Georgetown University. He has written numerous articles on investment, law, and public policy. His writing has appeared in the New York Times, Wall Street Journal, USA Today, Washington Post, National Review, and many other publications. Levy has also discussed public policy on national radio and TV programs, including ABC's Nightline, CNN's Crossfire, Fox, The O'Reilly Factor, MSNBC's Hardball, and NBC's Today Show. His latest book, co-authored with William Miller, is The Dirty Dozen: How 12 Supreme Court Cases Radically Expanded Government and Eroded Freedom. Levy received his PhD in business from American University and his JD degree from George Mason University School of Law. Today, we are honored to welcome Mr. Levy to come talk about gun rights on campus.
How's this? Can you hear in the back?
Needs to be louder.
Louder?
We can.
Better?
That's better.
Okay. It's great to be with you. I am a Floridian, a lawyer. So I can tell you a lawyer story and a Florida story. So the lawyer story is this. You may have heard on the internet that Al-Qaeda announced that they have kidnapped 100 lawyers. And they said if the United States doesn't get out of Afghanistan within 14 days, they're going to begin releasing the lawyers. One by one for 100 days. So here's my Florida story. I come from Naples, Florida. Every story in Florida is about old age, and the average age in Naples is deceased. This is a story about a group of guys that resolved, this started when they were middle-aged, they resolved they were going to meet every 10 years in Naples for a reunion. It all started when they were 40 years old. They got together and they voted on where to go to dinner, and they decided they would go to dinner at the Ritz-Carlton because the waitresses there were very attractive and they wore these provocative outfits. 10 years go by and they're 50 years old, they get together for their second reunion and they vote, and they decide once again to go to dinner at the Ritz-Carlton because the food and the wine there is really spectacular. Fast forward another decade, they're 60 years old, they get together and vote, and they decide to go to dinner at the Ritz-Carlton because it's quiet there and sedate, and you can hear yourself talk. Another decade goes by, they're 70 years old, they get together, they vote, they decide to go to dinner at the Ritz-Carlton because it has elevators and wheelchair access. And then just a few weeks ago, they turned 80 years old and they got together and voted and decided to go to dinner at the Ritz-Carlton because they'd never been there before. Now, for folks my age, that's getting to be a little close to reality. Today, I'm going to talk about DCV Heller and some follow-on cases. As you may know, DCV Heller was the successful Second Amendment challenge to the DC gun ban. I was co-counsel to Mr. Heller in that case. So let me begin with this common sense statement. And that is that killers who aren't deterred by laws against murder are very unlikely to be deterred by laws against carrying guns. And so the anti-gun regulations that we had and still have in many cities in particular, municipalities, don't address the deep-rooted causes of violent crime. And I'm talking about things like illegitimacy, unemployment, dysfunctional schools, drug abuse, and alcohol abuse. So the cures for these problems are, of course, complicated and protracted. But that doesn't mean that while we're waiting on these cures, if we ever find these cures, that we have to become passive prey for criminal predators. So on strictly policy grounds, there's a pretty compelling argument to be made that Americans deserve an opportunity to defend themselves by possessing suitable firearms. But even if the policy argument were to cut the other way, that is to say, even if you could demonstrate, and I want to hasten to add that I don't believe you can, even if you could demonstrate that more gun laws lead to less crime, this is not just about policy. This is about the meaning of the Constitution, and of course, in particular, the meaning of the Second Amendment. And happily, on June 26th of 2008, the highest court in the country ruled that the Constitution forecloses an outright ban on handguns, which is what they had in Washington, D.C. And what that means is that if we Americans decide, and I believe if we did so that we would be mistaken in having decided this, if we decide that a ban like they had in D.C. is required for public safety, the remedy is go change the Constitution. We cannot simply ignore the constitutional provision and act as though the document didn't exist. As a nation, we've chosen to have a written Constitution for good reason. It has served us very well for more than 2 centuries. And so we have to consider not just the policy question of the relationship between gun laws on the one hand and public safety on the other. We have to consider the constitutional question, the question that divided Second Amendment scholars for many decades, and that is, does the right to keep and bear arms belong to us as individuals, or does the Constitution merely recognize the collective right of the states to arm the members of their militias? In 1939, the Supreme Court had a chance to resolve that question. It was a case called United States versus Miller, and the challenge statute required the registration of machine guns, sawed-off rifles, sawed-off shotguns, and silencers. Regrettably, the court did very little to illuminate, and I think much to mystify, the meaning of the Second Amendment. And the justice who wrote the opinion, James Clark McReynolds, it was riddled with ambiguities and established no definitive legal principle or useful guideline for any modern Second Amendment deliberation. It's a very interesting case. So the facts are quite extraordinary. In Miller, 2 mobsters, Jack Miller and Frank Layton, were indicted for knowingly transporting a sawed-off shotgun across state lines in violation of the 1934 National Firearms Act, which required the registration of weapons like sawed-off shotguns and the payment of a very substantial tax. So neither Miller nor Layton was charged with firing the gun or committing any crime involving the use of the gun. Instead, they were indicted for a technical violation of the registration and tax requirements. They challenged the indictment, arguing that it violated their Second Amendment rights, and they won in the lower court. So the United States, the losing party, appealed this case and went all the way up to the Supreme Court. And there's where the fun began. Because in the United States Supreme Court, Mr. Miller's attorney, now mind you, I'm talking about a case in 1939 that became the seminal Second Amendment case all the way up to 2008 when Heller was decided. 1939, United States versus Miller. It goes to the Supreme Court, and Miller's attorney, a guy named Paul Gutenson, sends the Supreme Court a telegram. He doesn't file a brief. He doesn't show up for oral argument. And his clients don't show up for oral argument. He sends the Supreme Court a telegram, quote, I suggest the case be submitted on the government's brief. Now, the government is the opposing party. Unable to obtain any money from clients to be present and argue the case. The seminal Second Amendment case was argued with only one party present and only one attorney present representing the United States. Quite extraordinarily, the court did nothing to reschedule the case or to appoint a different lawyer for Mr. Miller. And then Justice McReynolds produced this muddled opinion, and it's confused lawyers and law students and the public for many decades. But when it was all over, the Supreme Court had reversed the lower court's holding that the National Firearms Act violated the Second Amendment. The Supreme Court held that the National Firearms Act did not violate the Second Amendment, and the case was remanded for a new trial of Miller and Layton. But before the trial could be conducted, Miller was shot and killed by his henchmen. Layton agreed to a plea bargain, was sentenced to 5 years on probation, but the damage to the Second Amendment had already been done. So how should this Second Amendment be interpreted? Well, there are two clauses, as you know. The main clause, the right of the people to keep and bear arms shall not be infringed. I don't know what could be clearer than that. The right shall not be infringed. That defines the right and secures the right. But there is this troublesome prefatory subordinate clause, a well-regulated militia being necessary to the security of a free state. What's its purpose? Its purpose is to help explain why it is that we have this right. Not the only reason we have the right, but one reason, and that is to provide for the efficient operation of a militia. That's one reason among others. And so it is fair to say that membership in a well-regulated militia is a sufficient but not necessary condition to the exercise of your Second Amendment rights. If you are a member of a well-regulated militia, it is quite clear that you have a right to keep and bear arms. But that's not the requirement. That is simply one rationale for that right. Others would include, for example, the right to defend yourself, or the right to hunt, to provide food for your family. So imagine if the Second Amendment said this, and you'll hear that the syntax here is just about identical to what the Second Amendment actually says. Suppose the Second Amendment said, a well-educated electorate being necessary to self-governance in a free state, the right of the people to keep and read books shall not be infringed. Now, would anybody interpret that to mean that only registered voters, that is, the members of the well-educated electorate, have a right to read? Surely not. And yet that is exactly the interpretation that the collective rights advocates are proposing for the Second Amendment, applying the Second Amendment right only to members of the well-regulated militia. If the Second Amendment truly meant what the collective rights advocates contend that it means, then the language would be much more straightforward. It would say a well-regulated militia being necessary to the security of a free state, the right of the states to arm the members of their militia shall not be infringed. But of course, it does not say that. It says the right of the people. And that's the same term. It's a term of art. It's the same term that you will find in the First Amendment, the Second Amendment, the Fourth Amendment, the Ninth Amendment, the Tenth Amendment. 5 of the 10 amendments in the Bill of Rights use this term, the people. And of course, the Bill of Rights itself is the section of the Constitution that deals with the rights of individuals. So it's quite clear that First Amendment rights, for example, like speech and religion and press, belong to us as individuals. Ditto for Fourth Amendment protections against unreasonable searches. That's an individual right. Similarly, the Second Amendment, we secure the right of the people by guaranteeing the right of each and every individual person. Some say the Second Amendment were intended for the state. Indeed, it was not only not intended for the state, it was intended This is agreed upon across the ideological spectrum, intended in part as protection against the state. Protection against the possibility of a tyrannical government. Now, if you look at the Constitution, you'll find out that the militia is under the plenary control of the U.S. federal government. So imagine that you have a right that is designed in major part to be a deterrent against government tyranny, and that right could only be exercised in the context of a militia which is controlled by the very government that has the potential of being tyrannical. Now, this is not a right in any sense of deterrent. That's not a right exercisable only when, where, and how the government permits that could possibly be a deterrent against a government tyranny. Now, there are some folks that would argue, I think I would agree, that the threat of a tyrannical government is certainly not zero, but it may be less than it was at the time of the framing. But government's inability to defend us against foreign and domestic predators remains a serious problem. And the demand for police or army to defend us, it increases in proportion to our inability to defend ourselves. And that's why you'll find disarmed society tending to become police states. And you don't have to look very far to find that. I could look where I grew up in the inner city of Washington, D.C., and where the Heller case was litigated. And there you will find law-abiding inner city residents who are begging. They're disarmed by gun control regulations, and they are begging for police protection, mostly against the drug gangs, despite the terrible violation of civil liberties that this kind of police protection frequently entails. Now, I'm talking about things like curfews, anti-loitering laws, if you live in public housing, non-consensual searches of your home, civil asset forfeiture, even video surveillance in high crime areas. So an unarmed citizenry, it creates the conditions that could potentially lead to tyranny. So in that sense, the right to bear arms is prevented. It reduces the demand for police because we're able to defend ourselves. When the people are incapable of protecting themselves, then either they're going to be dependents on the state or they're going to become victims of the criminals. Interestingly, there are a lot of scholars, and most interestingly, including some on the left, who agree that the Second Amendment does secure an individual right, although it can be limited in some circumstances. So here's Harvard's Alan Dershowitz, a former member of the ACLU, and ACLU board member, rather, and he says, and I quote, "I hate guns. I want the Second Amendment repealed." But then he goes on to say, "I condemn foolish liberals who are trying to read the Second Amendment out of the Constitution by claiming it's not an individual right. They're courting disaster by encouraging others to use the same means to eliminate those portions of the Constitution that they don't happen to like." Harvard's Lawrence Tribe on every liberal shortlist for the U.S. Supreme Court, and Yale's respected liberal scholar Akhil Amar. They acknowledge there is an individual right to keep and bear arms, albeit it can be limited by reasonable regulations in the interest of public safety. So in that sense, Tribe and Amar and Dershowitz, they agree with gun rights advocates on two fundamental issues. The first is that there is indeed an individual right, not merely a collective right. And the second is the right isn't absolute. It is subject to regulation. So to the extent there's disagreement, it hinges on what constitutes permissible regulation. That is, where do you draw the line? And fortunately, help was on the way. In Washington, D.C., which was, at the time we brought the Heller case, the only judicial circuit that had not fleshed out its view of the Second Amendment, the U.S. Court of Appeals for the District of Columbia Circuit had another opportunity to interpret the Second Amendment and the 1939 Miller case. The case in Washington, D.C. that you know as Heller actually started out, it was called Parker versus District of Columbia. And I'll tell you why it changed in just a moment. But it was a straightforward constitutional challenge to D.C.'s draconian gun laws. It was litigated by Clark Neely, who's a senior attorney at the Institute for Justice, and me, and then the two of us hired Alan Gura, who actually argued the case. He's a private attorney in the Washington, D.C. area, and we litigated this on behalf of 6 law-abiding D.C. residents who wanted to possess a functional firearm where they live and sleep. So Heller was not about machine guns It was not about so-called assault weapons. It was about the right to own an ordinary garden variety handgun. And the Heller plaintiffs did not ask for permission to carry the gun outside the home. That is another question for another day. It's going to have to be litigated. Indeed, it is being litigated as we speak. The Heller litigation, however, is very simple. It's about a pistol in the gun, in the home for self-defense. You probably know that off and on over the years, Washington, D.C. has reclaimed its title, not just the nation's capital, but the nation's murder capital. The D.C. government has been totally ineffective at disarming violent criminals, but it's done a really superb job at disarming all of the peaceful and decent citizens in Washington, D.C. So these were the laws when the Heller case was litigated. For starters, no handgun could be registered in Washington, D.C. since 1976. That's 32 years before the Heller decision. No handguns. Across the board, no handgun. Now suppose you had a handgun in 1976 when the ban was passed. You could keep it. It was grandfathered. You could have it in your house, but you couldn't carry that gun from room to room in your own home unless you had a permit, and D.C. hadn't issued a permit in 32 years. How about a long gun? Suppose you had a rifle or shotgun. Yeah, you could have that in the home, but it had to be unloaded, and if you loaded it, you're subject to arrest. It also had to be either trigger locked or disassembled. So unless you were planning on clubbing somebody over the head with that gun, and the rule in D.C. was that nobody at any time in any place could have a functional firearm in their own home. The law applied to every resident of D.C., not just to unfit people like felons and some felons and minors and crazy people. It applied to everybody across the board in every residence in D.C. There were a lot of challenges filed, more than 36 challenges to Washington, D.C.'s gun ban. But they are invariably filed by criminals who were serving longer sentences for using a gun in the carrying out of a crime. The Heller case was quite different. It was a civil case. The original plaintiff, as I mentioned, was a lady named Shelley Parker. And she lived in a high-crime neighborhood in the heart of D.C. People on her block were continually harassed by the drug gangs and the addicts, and she decided she wanted to do something about it. So she calls the police, and she complains. She does it time and again. She encourages her neighbors to do the same thing. She organizes block meetings to discuss the problem, and for her audacity, she's labeled as a troublemaker by the dealers, and they threaten her at every opportunity. So a year before we filed the case, the back window of her car was broken. A large rock is thrown through her front window. Somebody stole the security camera in front of her, the outside of her house. A drug user actually drove his car into and through the back fence of her house. And then in the year we filed the case, a dealer pounded on the door of her home, trying to pry his way in using a crowbar, cursing and yelling, "Bitch, I'll kill you. I live in this neighborhood too." He's charged with felony threat. He's acquitted, her word against his word. Shelley Parker knew that the police in Washington, D.C. were not going to do very much about the drug problem on her block, and she wanted a functional handgun to be able to defend herself, but she feared arrest and prosecution because of D.C.'s, now we know, unconstitutional gun ban. A second plaintiff, the plaintiff for whom the case is now named, Dick Heller, he was a private police officer, worked for a private firm, and he spent every day carrying a gun and guarding the Third Marshal Office building in Washington, D.C. But when he applied for permission to take that gun home and protect his own home and his family, D.C. said no, just as they say no to everybody. A third plaintiff was a gay man who was assaulted outside of D.C. on account of his sexual orientation. He's walking to dinner with a co-worker, and he encounters a group of young thugs who start yelling, "Faggot, homo, queer, we're going to kill you, they'll never find your body." Well, he was not in D.C. He had a handgun in his backpack. He pulled it out, and predictably his assailants were not quite as brave as they had been before. He couldn't have done that in Washington, D.C. So the 6 plaintiffs in the Heller versus District of Columbia asked a federal judge to prevent D.C. from barring the registration of handguns across the board, from banning the possession of functional firearms within the home, and forbidding these firearms from being carried from room to room without a permit, which you can't get. The plaintiffs lived in the district, they paid their taxes in the district, they obeyed the laws in the district, but DC said if somebody breaks into their home, their real choice is we call 911 and pray that the police arrive in time. If you've ever been in DC, you know that's not a high probability. The right to you can actually get a pizza delivered before you can get 911 in Washington, D.C. Well, in March of 2007, the D.C. Circuit, the second highest court, the U.S. Court of Appeals for the District of Columbia Circuit, Senior Judge Lawrence Silverman issued what I think is fair to characterize as a blockbuster opinion in Heller, and he held that the Second Amendment protects an individual right to keep and bear arms, and then he continued, and this is a quote, "The right is not limited to militia service, nor is an individual's enjoyment of the right contingent upon his or her continued or intermittent enrollment in the militia." So with that historic proclamation, Washington, D.C., the D.C. Circuit became the very first appellate court ever to overturn a gun regulation on Second Amendment grounds. 68 years before that, you had this Miller case, which mistakenly concluded that Second Amendment rights attach to specific weapons, not to specific people. The holding in Miller was that the sawed-off shotgun, which was at issue in Miller, that they had carried across state lines, had to bear some reasonable relationship to a well-regulated militia. And since there was no showing in the case that there was a relationship between sawed-off shotguns and and efficient militias, therefore that regulation was permissible. Now that's perfectly reconcilable with the Heller case. So Miller was not overturned by the Heller court. All Heller said is that there is a right that attaches to individuals as well as to weapons. And in this case, the weapon at issue was a pistol. And pistols, self-evidently, are related to the efficiency of a well-regulated militia. They are specifically mentioned in the Militia Act, and in fact they've been carried into battle by American troops every conflict since the Revolutionary War. So there's no conflict between the Miller case, which said that the right attaches only to weapons which preserve the efficiency of the militia, and the Heller case, which says, well, in this case, the weapon does preserve the efficiency of the militia, and by the way, the right attaches not just to the militia members, but also to individuals. For those of us who were eagerly awaiting a comprehensive, and I think comprehensible, Supreme Court statement on the Second Amendment that at least defogged the Miller case, the Constitution was on our side. Now that didn't mean that the D.C. government couldn't regulate firearms. Silverman, in his opinion, and Justice Scalia has said much the same thing in his opinion for the Supreme Court. They conceded that the protections of the Second Amendment are subject to the same sort of reasonable restrictions that apply to other amendments, like the First Amendment. If you pick up the Constitution and you read Amendment number 1, it says, "Congress shall make no law infringing on free speech." Now, I don't know what could be clearer than that. Congress shall make no law. But what do we have? We have laws that say you can't engage in certain forms of pornography. You can't falsely shout fire in a crowded theater. You can't incite to riot. You can't lie in commercial advertising. You can't engage in some forms of political speech connected with a campaign. So when it says Congress shall make no law, it means Congress makes all kinds of law. So these protections of the amendments to the Bill of Rights, they're not absolute. What they do is they set up a presumption. The presumption is you have the right, it's government's burden to justify any imposition on that right. So Silverman and Scalia both said, well, perhaps D.C. could justify things like concealed carry restrictions or registration or proficiency testing, and certainly no gun possession by violent criminals or by crazy people or by 7-year-olds. But what they can't justify is an across-the-board ban on all firearms in all places for all residents at all times. That's not a reasonable restriction. In fact, it's not a restriction at all. It's an out-and-out prohibition. And both the D.C. Circuit Court and the U.S. Supreme Court agree. So that's a little bit of background on the case. And what I'd like to do now is to give you some flavor of the anatomy of a real-life lawsuit, how these things come about, how the litigation unfolded from a practical perspective. And I think you'll be interested in particular in the NRA's role in all of this. So we litigated this on what's called as a public interest law firm. Public interest lawyers don't get paid. We represent clients who typically can't afford to pay us. The nice thing about being a public, the not so nice thing is you don't get paid. The nice thing about being a public interest lawyer is you can, whereas private for-profit lawyers cannot, instigate litigation. We can go out and try to drum up litigation. We could run a full-page ad in the New York Times. It says, we really have a pet peeve about the government's position on the Second Amendment. We want to litigate. Are any of you folks out there willing to be plaintiffs? Now, you're not supposed to do that. You're not supposed to instigate litigation if you're a for-profit lawyer. But I suppose the theory is that since we're not getting paid, there's no perverse incentive for us to drum up frivolous litigation. Another interesting thing about public interest law is that you can litigate the case, or you can actually argue the case in two different venues, two different courts. There is, of course, the law court, but there's also the court of public opinion. Even if you lose in the law court, if you can get the public on your side, there's a pretty good chance that you'll get legislative relief. And to digress for a moment, if you want an example of that, probably you've heard of this case up in Connecticut about eminent domain called Kelo versus City of New London. It was a huge loss in the Supreme Court. The case involved taking Mrs. Kelo's home and the home of her neighbors. Why? So that Pfizer could build a pharmaceutical plant and some private developer could put up hotels and office buildings. And the Supreme Court actually said, even though the Fifth Amendment says you can't take private property except for public use, the Supreme Court said this would be okay. It may not be a public use, but it is a public purpose. We're creating jobs, and we're increasing the tax base. So nobody's home is safe from the government bulldozer. This was a huge loss. But what did the law firm do, the public interest law firm? After they lost the case, they took it to the court of public opinion. And as a result of a media crusade, there are 43 states now that have overturned the effect of the Supreme Court case, at least with respect to state law. They can't overturn, of course, federal law, but with respect to state law, now these 43 states give you more protection as an individual homeowner than the Supreme Court was willing to give you under the federal Constitution. So that's two good things about being a public interest lawyer. You can instigate litigation and you can go to the court of public opinion. And what it means is that when we look for plaintiffs, we want to present the very best case possible, both from a legal point of view and from a media point of view. And so our criteria in searching for plaintiffs, among other things, we wanted gender diversity, we wanted racial diversity, we wanted economic diversity, we wanted age diversity. We had to have D.C. residents who fervently believed in the right to defend themselves in their homes, not just mouth the words and say, we think we would like to have a gun. They got to feel that they're at risk, that they're unsafe, and they really do need a weapon, because that is the best story to present to both the court and to the media. And they had to be articulate, because we knew that they would be dealing with the media. So net result, we picked people with good facts. Mr. Heller, as I mentioned, guarded a federal office building, carried a gun all day. Ms. Barker was threatened by drug gangs, and Mr. Palmer was accosted by homophobic thugs. We interviewed dozens of plaintiffs to come up with the 6 that we liked. 3 men, 3 women. They ranged in age from their mid-20s to their early 60s. 4 of them were white, 2 of them were African American. They ranged in occupation from a communications lawyer to courthouse security guard. With respect to funding, there were offers of funding from the usual suspects, the various gun rights groups, but we didn't want Heller portrayed as litigation that the gun community was sponsoring. Not that there's anything wrong with the gun community, but this was more compelling and more convincing if it was sponsored by persons that were not affiliated with the gun community, and the 3 of us who litigated the case were not affiliated. So we rejected offers of funding, and we decided to provide the funding ourselves. Clark Neely did it by working for free. I did it by putting up a few bucks and working for free. And Alan Gura did it by working for probably subsistence wages. He violated the minimum wage. Why did we litigate in Washington, D.C.? Washington, D.C. was a unique and appropriate venue for a number of reasons. First, the rate of gun violence in D.C. was just about the highest, or the next to highest in the nation. Second, D.C. had the most restrictive gun laws of any major city. So here you have the perfect combination of litigated case. The very most restrictive gun laws and the very highest rate of violent crime. Third, and very important, the applicability of the Second Amendment to the states had not been resolved. So all we knew was that the Second Amendment might apply to the federal government, but we didn't know whether it would apply to the states. And so by bringing it in Washington, D.C., which is a federal enclave, it's not a state, we could get rid of that nasty subordinate problem and let the court focus on the important issue, which is what does the Second Amendment mean. And then finally, D.C. is where the federal government lives. And that means that if you have a Second Amendment challenge you want to litigate, you can always litigate in D.C. The D.C. is always an appropriate venue, a proper place to bring a lawsuit, because you can always sue the defendant in the place where the defendant lives. And that means D.C. was the most important of all the judicial circuits, because even if an infraction, even if your rights were being violated in Utah, you could litigate in Washington, D.C., and so a victory in D.C. about the meaning of the Second Amendment would effectively have an impact on cases that arose out of violations of Second Amendment rights all across the country. The approach was an incremental approach, and that is, by that I mean don't bite off more than you can chew. So this is the same thing that Thurgood Marshall did when he litigated the civil rights cases. So Heller was a straightforward constitutional challenge to D.C.'s gun laws, and it was all about a handgun in the home. So it didn't get involved in more elaborate weaponry. It didn't get involved in outside carry. It didn't get involved in any statutory infractions or procedural infractions. It was a very basic case. And now what I think is some just interesting history about the NRA. The Cato Institute, where I chair the board, often is allied with the NRA on gun rights issues. Sometimes we're not. We have some disagreements about some non-gun issues, and we have even some disagreements about gun issues. But in any event, we have a working relationship, and so we notified the NRA when we decided, the three of us decided that we were going to bring the case. The NRA said, don't do it. Why? Well, because it's really a good case, and you got great facts and great plaintiffs, and you may win in the appellate court. And we're a little bit worried that we don't have the horses on the Supreme Court, so you might win the battle, lose the war. Now, it turns out the NRA wasn't far from wrong. You know, this was a 5-4 decision, so it's not as if this was a slam dunk, and it was pretty clear which way the Supreme Court was going to go. It wasn't clear at all. So I attribute this to a heartfelt belief by the NRA that it was a real risk to go take this up to the Supreme Court. Well, we didn't follow their advice. We thought the Supreme Court looked pretty good, and we were worried about other cases coming up challenging the Second Amendment, where you'd have a crackhead or a bank robber as the poster boy for the Second Amendment. We didn't want that. And there was this factor, that even if we lost in the Supreme Court, that doesn't mean that the states can't give you more rights than the federal government gives you. And as you folks know, 47 states have concealed carry. 49 states have concealed carry. It's only Illinois right now that doesn't have concealed carry. So under state law, even if you lost on the federal Second Amendment, under state law, there's a great deal of protection for gun rights. For those reasons and others, we went ahead and decided to litigate, even though the NRA had urged us not to litigate. Well, the NRA decided they didn't want to stand on the sidelines and watch three guys that weren't connected with the NRA litigate the most important Second Amendment case come down in 70 years. And so the NRA filed a parallel case, a copycat case, in the same court, raising the same issues with 5 different plaintiffs. And then they moved to consolidate the 2 cases in an obvious attempt to take control of the litigation. We resisted that. That took 3 to 4 months. And a separate case involving whether or not to consolidate, and we won that case. And so the 2 cases, their case, which was called Seegers v. Gonzalez, and our case, which was called Heller versus District of Columbia, the 2 cases were not consolidated. They both moved along on a parallel track. Now, the way it works in court, in the federal court, is your case gets assigned to a U.S. District Judge. And the assignment is random. So you don't know which judge is going to get your case. And these judges have varying levels of energy and varying, their dockets are not all equally busy, so some of them move quickly, some of them don't. We filed a case months before the NRA. They filed months afterward, and yet they got a decision before we did. even though their case never even got to the judge until months after that case did. They lost in the district court. So they appealed to the Court of Appeals. And while they're appealing, we lose our case in the district court to a different judge. A judge who had the case a long time before the NRA case, but who took his time. And we appeal. And then the appellate court says to us, we're going to have to postpone your case because there's no sense in our dealing with both of these cases. They both raise the same issues. They're both in the same court. And frankly, if we deal with the NRA's case, which got here first, it's going to dictate the outcome of your case. And then if the NRA wins, you win. If the NRA loses, you lose. So there's no sense in taking both cases. So we were dead in the water. And the NRA had accomplished exactly what it intended to accomplish, which was to take control of the litigation. And then the NRA loses in the appellate court. And the appellate court allows us to go forward. Now, why would they do that? I mean, why, if the NRA loses, doesn't that dictate the outcome in our case? Because the appellate court in the NRA case never did get to the Second Amendment issue. It never even addressed the Second Amendment. What it decided was that none of the 5 plaintiffs had standing to sue. Why? Because they were not injured. All they said was, we want to have a gun. They didn't go out and get a gun. They didn't apply for a gun. They weren't prosecuted for having a gun. So they were not injured. Their injury wasn't sufficiently credible and imminent. And those are the standards. You have to be injured in order to bring a lawsuit. So, because it didn't reach the Second Amendment, our case was allowed to go forward. 5 of our 6 plaintiffs get thrown out for the same reason. No injury. 1 plaintiff survives, Mr. Heller. And that's why the case changes its name from Parker versus District of Columbia to Heller versus District of Columbia. How did Heller get standing? He's the only one that applied for a gun permit and got turned down. That was his injury. He didn't have to get arrested. All you have to show is that you're injured. And if you apply for a permit and you get rejected, that's an injury. So Heller could show that he was injured and therefore he had standing. Now you might say, why were we so stupid and we didn't get the other 5 guys to apply for a permit? And why was the NRA even dumber than we were? They didn't get anybody to apply for a permit. And the answer is, it's catch-22 in Washington, D.C., and this will show you how absurd the law can be at times. And the law says, if you want to apply for a permit, you can't do so in Washington, D.C. on an imaginary gun. You have to have a gun in order to apply for a permit. Well, you can't get a gun in Washington, D.C. There's an outright ban on purchasing guns in Washington, D.C. Why not go to Maryland or Virginia and get the gun? Well, because federal law says you can only buy a handgun in the state where you live. So, in order to apply for a permit, you have to have a gun. And in D.C., you can't get a gun. You can't get a gun in the neighboring states. Net result, no application. No application, no denial. No denial, no standing. No standing, no lawsuit. So how did Heller do it? He got a gun a decade earlier when he lived outside of D.C. He moved back to D.C. Couldn't bring the gun because that would be illegal, but he could bring the paperwork. So he could prove that he had a gun. And that was sufficient for him to apply for a permit, which was, of course, denied. It was a rubber stamp process. Nobody got a permit in D.C. And that meant he had a standing. And so his case could go forward, even though our other 5 plaintiffs could not go forward, and none of the NRA's plaintiffs could go forward. So we thought the NRA was finally on board, but it was not to be. The NRA then, finding out that they could not proceed with their case in court, went to Congress and tried to get the D.C. gun ban repealed. Now, ordinarily that would be a good thing. But if you repeal the gun ban, you moot. That's the legal term. The lawsuit, and by moot, I mean the case gets thrown out. The lawsuit can't challenge a law that no longer exists. So if the law is repealed, the Heller case goes away. The case would be dismissed by the court. So I actually testified in Congress against repeal of the D.C. gun ban. I made it quite clear to the Congress that I was in favor of repeal of the D.C. gun ban, but not by Congress. I thought it ought to be done by the courts. Why? For 2 reasons. One is a decision by the Supreme Court would have nationwide implications, whereas a decision by Congress would only affect Washington, D.C. And second, the Supreme Court is the highest authority in the land. Congress changes every 2 years. So every time Congress changes, there is the potential that any repeal gets reversed and it gets reinstated. So that was a major lobbying effort, and we finally got that bill bottled up, and the DC gun ban was not repealed by Congress, and the NRA finally joined forces. And when they decided to join forces, they are a formidable ally. And they filed a very important brief in the Heller case that was signed by a majority of all the House representatives in the House, a majority of all the senators in the Senate, and by Vice President Cheney in his capacity as president of the Senate. Well, as they say, the rest is history. In D.C. v. Heller, which was the final opinion of the court's 2008 term, Scalia effectively rewrote the court's Second Amendment jurisprudence, and he held first that the Second Amendment protects an individual right for self-defense, even if unconnected with militia service, and second, that Washington, D.C.'s ban on all functional firearms is unconstitutional. Now, let me close by commenting briefly on how much time do we have?
It's 10
10 minutes left for Q&A.
10 minutes?
Mm-hmm.
Okay. I'll comment very briefly on a couple of issues that receive less attention, but I think have significant implications for the future. One is what gun regulations will now be permissible, and the second is what did the court say regarding the applicability of the Second Amendment to the states, and that was a follow-up case. Scalia acknowledged this first issue, what gun regulations are now going to be permissible. By the way, late breaking news, I'm sorry to say that the U.S. Court of Appeals for D.C., this very same court that decided favorably on the Heller case, issued an opinion this morning. I haven't read it because I just got news over the email that said that Washington, D.C.'s ban on what they call assault weapons and on magazines with more than 10 rounds is constitutional, even after the Heller case. So this is a three-part issue. Part one, what's the Second Amendment mean? That was taken care of in the Heller case. Part two, where does the Second Amendment apply? And I'm going to talk about that in just a second. That was the McDonald case in Chicago. Part three, what does the right, what's the scope of the right? What kind of regulations is still going to be permitted? And that's going to be fleshed out over a long period of time, maybe a decade. And it's happening right now in one decision, as I mentioned, came down today. So how do we know which rights are going to be approved and which regulations are going to be approved and which regulations are not? Scalia said in his opinion that the court has occasionally sanctioned concealed carry. Certainly, you can prohibit guns from being carried by crazy people or by 7-year-olds. Everybody understands, even the most rabid gun rights advocate understands that the right to keep and bear arms doesn't mean that a 7-year-old can have an automatic weapon in front of the White House when the president is delivering a speech. So quite clearly there are some things that can be regulated. That's this whole issue about whether rights are absolute. What this is going to boil down to is what level of scrutiny does the court apply in reviewing regulations. This is a very complex legal issue. We are hopeful that the court will require the government to jump through 3 hoops in order to justify regulation. Bear in mind that because Heller was decided in favor of the plaintiffs, and the court did decide that there is an individual right, the effect of that decision is to shift the burden to the government. It is now up to the government to justify its regulations. It is not up to us, if we want to carry a gun, to justify that we need to do so. It is up to the government. We would hope, in reviewing these regulations, that the court will rigorously review the government's proof that the regulation is necessary and will require 3 things of the government. First, that the need for the regulation is absolutely critical, compelling. Second, that what the government proposes to do in the way of regulating is going to be successful at accomplishing the ends that the government seeks to have accomplished. And third, that they couldn't have accomplished the same thing in a way that wouldn't have trampled on Second Amendment rights. We don't know what standard of review the court is going to apply. We will know more as these decisions are threshed out. What did the court say about applying the Second Amendment to the states? Heller resolved the meaning of the Second Amendment, but D.C. wasn't the whole story, so we have to look at McDonald versus Chicago, which was resolved in 2010, and that found that the Second Amendment applies not just to federal enclaves like D.C. Imagine if you had a Second Amendment only applied to D.C., Guam, Samoa, the Virgin Islands, and Puerto Rico, but not to Illinois. So the McDonald case found that the Second Amendment does apply to states and localities as well as federal enclaves. And as I said, that's why we filed in D.C., because we didn't want to deal with that on the first case. It takes the second case, the McDonald case, to deal with that. Now, here's what some of you may not know, unless you've studied constitutional law. Until the 14th Amendment was ratified after the Civil War in 1868, the Bill of Rights only applied to the federal government. You notice if you read the First Amendment, it says Congress shall make no law. It doesn't say anything about the states. So the state of Maryland could have passed a law that says you can't practice Catholicism or you can't criticize the government. Now, maybe that would have violated the Maryland Constitution. It would not have violated the federal Constitution, the U.S. Constitution, because the Bill of Rights did not apply to the states. It only applied to the federal government. We found out over the first 70 or so years that the states can be every bit as tyrannical as the federal government, slavery being the obvious case in point. And so we fight a civil war, and we have a number of post-Civil War amendments, including the 14th Amendment. And the 14th Amendment says that no state can deny to persons due process of the law, equal protection of the law, and privileges or immunities of citizenship. The 14th Amendment was used to apply the Bill of Rights to the states. So because the federal government was given the authority to step in and stop the states if they were found to violate speech, press, religion, unreasonable search, etc. Because of that, the 14th Amendment is said to have incorporated the Bill of Rights so that it applies to the states. This process didn't all happen in one fell swoop. So we would have cases litigating the right to free speech and whether that applied to the states, religion, press, unreasonable searches, and until 2010, in the McDonald case, no one had ever addressed whether the Second Amendment applies to the states. And the McDonald court determined that indeed, like most of the other provisions in the Bill of Rights, the Second Amendment right to keep and bear arms does apply to the states. And what that means is that should spell the end for some of the draconian state and local regulations that constructively bar the use of firearms for self-defense. Now, it may be that sensible regulations will still be allowed by the courts. And I, for one, applaud that. But sensible has to be properly defined, and sensible is not what we have. Well, certainly not what we had in D.C., it's not what we have in New York or Chicago, San Francisco, or many other major cities. Thankfully, I think Heller and McDonald, Heller took a major step to restore sensibility, and McDonald took the second step in making that applicable nationwide. And I think that is a big win for common sense, and more importantly, it's a big win for the U.S. Constitution. So thanks very much, and I'll answer whatever questions.
Yeah, I just had a question about property rights and gun rights. Like here in Utah during the last legislative session, I think there was a bill introduced by one of our local legislators that had to do with, like, say a hotel owner doesn't want a gun on his property. How do you feel about that? You know, do property rights trump?
Here's one area where the Cato Institute and the NRA differ. This came up in the context of whether or not a corporation could preclude guns being held in automobiles on corporate property. The NRA said this is a Second Amendment issue. I don't think it's a Second Amendment issue at all. The Second Amendment, bear in mind, the Constitution is not a code of conduct for individuals. The Constitution is a restriction on the behavior of government. That's what the Constitution is all about. So unless government is misbehaving, the Second Amendment doesn't apply. There's no misbehavior when this is private property. Our position at Cato is, not the NRA position, but our position is that a private property owner should have the right to permit only gun owners to be on his property, only non-gun owners, neither of them, or both of them. And he should be able to permit that for good reason, for bad reason, or for no reason whatsoever. So property rights trump when it's private property. Yes, sir.
On the topic of sensible regulation, it seems like there's a black and white view on a lot of you're either gun rights or pro-gun control. But I think there's a gray area, and that comes down to the different regulatory issues, and you talked briefly in your speech on sensible regulation and other things. The issue I want to bring to light is, for example, the restriction of certain individuals to own firearms. That currently is done on state levels as well for felons. Now, the defining line here, with the exception of domestic violence, the defining line is misdemeanor to felony. And you spoke about the Second Amendment trumps state regulations on certain things. Like, for example, the state of Utah in its constitution has verbiage on gun rights to the point of you have the right, but the state can regulate it and issue laws that can constrict that. And also, you spoke on 3 premises in which the government should have to consider, per se, to be able to create those regulations and or restrictions. How do you feel about that?
Well, this is being litigated, again, as we speak, this dividing line between misdemeanors and felons. I think it's an arbitrary dividing line that really doesn't make a whole lot of sense. The dividing line ought to be based upon the nature of the crime that was committed and whether or not a gun was used in the crime and whether or not there were violence involved in the crime. So really and there are some felonies, of course, that don't involve any violence whatsoever. And there are some misdemeanors that do involve violence. So that seems to me to be a more rational guideline, and the courts are going to have to thresh this out. But there are cases now that are being litigated to address the prohibition of gun rights to felons who have never committed a violent crime. It does seem to me to be outrageous, and I would hope the courts will go along.
Now, would like you explained, that Second Amendment trump a state constitutional a law or amendment that would say, for like Utah, well, we get to decide?
The nice thing about this issue, it's going to be whichever gives you the best deal. So if the federal Constitution is interpreted by the federal courts as protecting a felon who hasn't committed a violent crime and giving him gun rights, maybe they would do so after a certain period of time. Whatever the rule is, if the U.S. Constitution is determined by the federal courts, that would trump any state constitution. On the other hand, if the state constitution is interpreted by the state courts as providing that right, that would trump the U.S. Constitution. Bear in mind, the U.S. Constitution says you have the right. It doesn't prohibit you from having the right. There's nothing in the U.S. Constitution that says a felon can't have a gun. What there is something that says you have the right to keep and bear arms. So it's a permission in the U.S. Constitution, not a prohibition. Whichever source of authority gives you the best deal is going to trump. On that issue. Yes, sir.
What do you deem the likelihood of LVDC being overturned by a future court?
Not very high. The courts are very reluctant to overturn past precedent, particularly in an issue that's, this issue is probably as emotional for people, any issue other than maybe abortion. And it has political sensitivity, as I'm sure you all know. And the NRA, however ill I may have spoken of them during the talk, they are a formidable gun rights organization, and they do great work, and they have enormous political clout. So I don't think that the Supreme Court wants to wade into this political thicket again if they can help it. And I do think the Supreme Court wants stability and predictability and certainty in the law. And any time the law starts changing over short intervals, that diminishes respect for the law. And the court, I think, is sensitive to that. Yes, sir.
There's a number of issues that a lot of people familiar with gun rights are aware of. California's got May issue status, where a law enforcement officer says, we don't believe you have significant right to get a concealed carry permit. There are other issues like the like the sporting purposes language that a lot of laws use. What do you see is going to be the biggest target to attack down to help increase the meaning of the Second Amendment as it is now?
Yeah, well, and look, if concealed carry prohibitions are deemed to be constitutional, then certainly May issue is going to be constitutional. So if you can issue with discretion, that's more liberal in terms of protecting your rights than if you're not going to issue any permits at all. And I don't know how the court's going to.
Well, it's not so much about how the courts are going to, which one do you see is going to be the best one to attack on the rights? And as far as the may issue status, you are right, you know, it is, they are granting some permits, but there are notorious counties in California, New York, things like that, that won't issue them to anyone unless you're connected or rich.
The best approach, in my view, is the same approach we used in health, and that is the incremental approach. You attack the worst situation first, and you proceed in increments. Get a good decision, try to build on it. The worst situation is in Illinois, where there's an outright prohibition on carrots. And so that's where you want to attack. Or in some municipality that has an outright prohibition. You don't go after may issue if you can go after an outright prohibition. The worse the situation, the better the likely result is. And then you try to build one. Yes, in the back.
How much weight do these little logical proofs we use, like a guns cause crime and pencils misspell and cars speed, how do those hold up in the high political circles if they've been used at all? And if they haven't, why not?
You're talking about the extent to which the court gives weight to the empirical data, to the statistical evidence? Is that what you're asking?
Well, like a simple fact, like, you know, people will, you know, they'll sue firearms manufacturers like, oh, your thing, you know, your products kill people. But no one sues Ford and Jack Daniels for someone drunk driving and not going after the person that was driving it. Why is it seems that that's okay for firearms and not other things, when logically it's still an inanimate object, that the end use of it is up to the user?
Yeah. Well, this probably doesn't come under the rubric of the Second Amendment. This is tort law, and whether or not a manufacturer can be sued for unreasonably dangerous products that he sells to the public. And the rule that I think ought to prevail is that if there's full disclosure, if there's a warning, then the consumer is on notice. And so any injury that occurs to the consumer himself is because the consumer voluntarily assumed the risk by buying the so-called unreasonably dangerous product. That does not, however, answer the question of what about injury to innocent bystanders. There's a more complicated question, but I think you're right that it's the same kind of question that occurs with respect to an automobile. And what this generally boils down to in the courts is a utilitarian calculus. That is, what are the costs involved of imposing these kinds of restrictions versus the benefits involved when the restrictions are imposed. How much is public safety improved on the one hand, how much inconvenience and excess cost, and that's what the courts will weigh in making these kinds of determinations. But it's not a Second Amendment issue. Yes.
Since the Levy DC case was decided, and in reality, have we seen any changes in the laws in DC or laws in general because of that case? Or obviously, people that made those laws would be somewhat reluctant to change.
Yeah, well, all three of the laws that we challenged in DC have been repealed. So there's no longer a ban on handguns in the home. There's no longer a ban on carrying a handgun from room to room in the home. And you can now keep rifles and shotguns loaded, and they don't have to be trigger locked or disassembled. There is a provision that says if kids can have access to the guns, there has to be some kind of safety mechanism. That could be a storage mechanism or a trigger lock. But what DC hasn't done, and what's again still being litigated, again, this stuff happens slowly. It takes a long time. It took us filing a case in 2003. We didn't get a decision in 2008. That's 5 years of litigation for the one case. So what's being litigated now are several things. One is that DC is such a burdensome procedure for becoming a retailer that there are no gun retailers in DC. So what good is the right to keep and bear arms if you can't buy a gun? There's nobody in DC that will sell you a gun. Nobody. Zero. I don't mean one or two, zero. There was one guy, and he had nothing but a post office box. And the deal was you buy your handgun outside of DC, and he ships it to DC because federal law says you got to buy in the state where you live. And he went out of business. So the DC has these huge requirements for becoming a retailer, and that's a constructive ban, and it's going to be, it has been challenged, and it will have to be litigated. DC also has a much more rigorous background check than the Brady bill calls for. And so we're litigating that as well, to have DC comply with the Brady standards and not go beyond the Brady standards. And I personally would like to see this federal law changed. I think it's an absurd law that says you can't buy a handgun in any state except the state where you live. The law ought to be, you can buy a handgun anywhere you want, but you have to abide by the laws in the state where you're going to be possessing the handgun. Yes.
To your knowledge, have any courts, whether federal or state, defined what makes, like, as the words you used, a crazy person in terms of who can and cannot register a gun?
No, I don't know that anybody's come up with a definition of a crazy person. You know, we have the definitions that the courts use to define insanity. Either not able to distinguish right from wrong, or even if you are able to distinguish right from wrong, you're incapable of controlling your actions. That is, you have this impulse that's uncontrollable. So those definitions have been used by the courts in defining insanity, and I don't know of any formal definition of what crazy is, but it'll be different in each state. I don't think there's going to be a federal definition of crazy. I think the states will have their own laws, and the feds will simply overview those laws to see if they're within the scope of what's reasonable. It won't require, I don't believe, every state to have the same definition of crazy. Certainly people in Massachusetts, I think half of them.
Where do you draw the line in reasonable types of firearms that can be registered and carried? As I know, I'm supportive of gun rights. I have no problem with handguns or rifles or shotguns, but I'm leery of someone being able to just openly carry a machine gun on my campus.
Yeah.
And I feel that a lot of gun rights groups shoot themselves in the foot by going that far extreme and losing more moderate gun control supporters. Where do you think the line should be drawn?
Well, it's a tough question, and again, it's a question that's going to have to be fleshed out by the courts. There's this interesting turn that question around. The gun control folks have always said that this is a right that only applies to military weapons. So if you take that to its logical conclusion, it means you can't have a weapon that's not used by the military, like a sawed-off shotgun, but you can have a rocket-propelled grenade, or you can have a nuclear, who knows what, right? So the whole nonsense about the weapon only usable in a military context, I don't think makes any sense at all. And the courts have come up with a slightly different rule, and that is the weapon, in order to be protected by the Second Amendment, has to meet two criteria. First, it has to have military use. You remember I told you about it. It has to lend itself toward the efficiency of the war-regulated militia. Even though the right extends beyond the militia, but the weapon itself has to be the type of weapon that would promote the efficiency of a militia. And the second criteria, I don't know where the court gets this one from, it has to be in common use. In common use. So that rules out nuclear weapons, because we just don't have those in everybody's backyard. So they're not in common use. Of course, there's a good deal of circularity in that definition, because what's in common use will tend to be what the court permits people to have. And what the court permits people to have turns out to be in part dependent on what's in common use. How do you break that chain? I have no idea. But this is another subject that's going to have to be litigated. I think you're right, though, that, and by the way, with respect to automatic weapons like machine guns, they have been effectively banned since the 1934 National Firearms Act. Not completely. You can get one, you pay a fortune, you go through all kinds of hoops, it takes forever, and the machine gun can't be manufactured after 1983, or it's completely banned. So there's some exceptions, but effectively, these kinds of automatic weapons have been banned since 1934. The court has said nothing about that. The ban stays in place. Nobody's even contemplating challenging the constitutionality of that thing.
So
Let me see if somebody had any question. Yes.
I have a box cutter and I have knives in the kitchen. They're real common. and I don't have to register them, permit them to carry, or anything. The government doesn't need to know that I own them. And that's what, I'm wondering where you come down, where does the courts come down, but just on the idea of the government knowing, even knowing you have a gun is not a good thing. And those weapons, you know, like knives and box cutters are used by military, right? They were used on 9/11.
Well, this is the intersection of law and policy. You remember I said, I think right at the beginning, that even if you could show that more gun laws do in fact make us safer, that this is not just a policy question, it's about the meaning of the Second Amendment and the U.S. Constitution. So it's not sufficient to show the policy argument. But there is some intersection, and it works like this. Once you've decided, and the Supreme Court has decided, there's an individual right to bear arms, and then nobody thinks that the right's absolute, then the court is going to have to decide what kinds of regulations are permissible. And in making that decision, deciding what regulations are still going to be permissible, even though there's an individual right, the court engages in this scrutiny that I mentioned. They rigorously review the regulations. How do they review? They look at costs and benefits. How do they look at costs and benefits? By treating the policy arguments. By looking at what's the utility of having a box cutter and a knife versus the utility of having a gun. Well, they decide, and I think it would be plausible to decide, that that box cutters and knives have a hell of a lot of uses besides shooting people, and the guns have a lesser number of uses over and above shooting people than do knives, right? So I'm not suggesting that's the answer to your question.
No,
That
I
is
was
something
more
that the court-
answering why does the government, I mean, I don't like the idea that the government has a list of who owns a gun. I mean, that can be used in all sorts of ways by, you know, a devious politician, right, or whatever. And I just don't like
Yeah,
the
the
idea of
government's
gun
not
is a
supposed to
dangerous
have that.
thing, right? But it
The
could be
government's not
used.
supposed to have that. That list's not supposed to.
Okay, so you support that it should, the government should not
It
have
should
a
not.
list?
No.
Okay.
The registration is of firearms, not of people. And the Brady information, the background check is supposed to be disposed of within a certain period of time.
Okay, I would wonder what you thought about the Patriot Act with suspension of habeas corpus, personal privacy rights.
Well, I think the Patriot Act has some provisions that ought to be changed, including the permission for roving wiretaps, the permission for the use of national security letters issued by the FBI, library searches, searches of computer disks. These are things that go too far, that don't have sufficient oversight outside of the executive branch. And so I would like to see those things changed. But I'm not one who thinks the entire Patriot Act ought to be declared unconstitutional. I do think the courts have restricted habeas, not in the context of the Patriot Act, but habeas has been, there's been a lot of cases about habeas. So we started off with this purely statutory question of whether people at Guantanamo are entitled to habeas, and the court has decided that anywhere that you can have service of process, you're entitled to habeas rights. But then the Detainee Treatment Act overturned what the court said and said no habeas for Guantanamo. But then the Hamdan case came along in the Supreme Court and said the Detainee Treatment Act was not valid because it's basing it on military tribunals, which weren't constitutionally authorized. Then Congress went ahead and constitutionally authorized military tribunals, and then the court in the Boumediene case said, no, Congress didn't do a good enough job, they're still not constitutionally authorized. So there's been an enormous amount of litigation on habeas, but it's not connected with the Patriot Act. There are parts of the Patriot Act I'd like to see changed, but not all of the parts.
Do you think there's some further debate that Congress should be making on habeas? But we hardly debated it at all before passing that act. Do you think it was going
I think the
premature?
debate's going to be carried out in the courts. You know, the Congress is not going to readdress this for a while, particularly now we're coming up in the context of the political season. Yes, sir.
I believe that people in general have been conditioned to fear weapons when it's not a police officer or military holding it. And I personally would like to see that change, and that's going to be that's a long shot of a goal. But how can I do that when carrying a weapon openly? I was told by the USU police today, just about 2 o'clock, that if I came here with an open carry, that I could be arrested if somebody complained because they were alarmed, because I'm disturbing the peace.
Well, I don't know enough about the local laws to tell you, whether the police were right in telling you that or they weren't right. But I think you made the wise decision not to test it. I assume you're not testing it. I don't see any.
We have time for one
So-
more question.
Okay, one more question. I'm sorry, I just don't know enough about the local. Okay, somebody who hasn't asked the question? Okay, all the way in the back.
You said that having guns is essential in case of, for various other reasons, but also in case of like a tyrannical rule. I can understand to prevent violent crime, but our military has scout drones where an operator can fly over, fire a machine gun from miles away by a remote control. What's a gun that we are allowed to have going to really do against that?
Well, first, I said that in the context of the conditions that existed at the time of the framing.
Okay.
And at the time of the framing, it was plausible that the citizenry would have weapons that would be an effective deterrent against the weapons possessed by the government. Now, I acknowledge that as the years and decades and centuries have gone by, the government has become so powerful that there's no way in the world that individuals could possess weapons. But, not every act by the government has as its final element the use of a nuclear weapon against its own citizens. So there's some weapons that protect against some government activities short of massive firepower. I think that goal, that is protection against the tyrannical government, is still a pretty good goal. And don't forget, you're not all talking only about the federal government. You're talking about states, localities, municipalities. There are all kinds of levels here where they don't have this massive firepower that the U.S. government has. Okay, thank you all very much for your attention. I appreciate it.